Good afternoon, everyone, and welcome to another edition of our Justice and Pieces guest speaker series as we've been talking to lawyer and paralegal bencher candidates about the upcoming election. As always, the views and opinions are of the candidates alone. They don't reflect me, Justice and Pieces, Trials College, or any other education institution or organization I'm affiliated with. Today afternoon, we have Michael joining us. So first of all, Michael, thanks so much for taking the time to speak with us. And perhaps, if anyone's not been paying attention to all the battles there with the Superior Court and all the work that you've been doing, maybe you could tell us a little bit more about yourself.
Well, JP, thank you very much for having me on your program. So I'm a litigation lawyer. I've been a lawyer, or I've been licensed since 2006 in Ontario since 2012. Over the last few years, and certainly with the onset of COVID, I've become very concerned with the performance of the Ontario Superior Court, which is brought home every time I try to file something, and it gets rejected one time out of two. So I've started to try to obtain some of the data that the Ontario Superior Court are not themselves obtaining or publishing, and making that known so that we can begin to take steps to modernize our court system and to make it internationally competitive, and essentially to see that it performs a little bit more like court systems in provinces like Alberta or jurisdictions like New York or Michigan, and less like lagging jurisdictions such as Italy, perhaps.
Now, in addition to that, in the last few years there, you've served as a bencher and you're running for re-election this time around. So what brings you to continue on and seek another term?
Well, I think the Law Society has a lot of work that continues to need to be done. Arguably, from an objective standpoint, we are the poorest run regulator in the province. We have the highest budget on a yearly basis at 141 million. We have the most staff members at about 570, give or take, which is very close to 200 more than the Ontario College of Physicians and Surgeons. And in some areas, specifically practice management, the Law Society is run very well. I'm impressed every time I come across or see the work that they've done. In other areas, such as the time it takes for matters to go from investigations over to prosecution at the tribunal, we can see things just drag on for years and years. And so clearly there's room for substantial improvement.
Now, I've spoken to a number of other incumbent benchers and people from the Good Governance Coalition that sort of characterize the last 4 years maybe as a step back. Part of it is the group, they're 22 elected together under this singular issue, and then pointing to things like the lack of civility or the need to bring civility back, and all sorts of points brought up there. But I'd love to hear your perspective on you've been a bencher for the last 4 years, and what was that like, and what are the things that may need to be further improved on, as you just pointed out?
I think one of the biggest things the Law Society needs to improve on most is to start getting and tracking more data, because certainly a lot of what I've observed and what I presume the Law Society did before was have very subjective discussions about whether green is a better color than orange. That are, they're very open-ended, they're unquantifiable, and they burn up a lot of time, they burn up a lot of money, but they don't actually deliver any measurable results. And ultimately the outcome of that is the Ontario legal system we currently have to a large extent. A few metrics, of course, that I think are significant are, number one, we have these ridiculous trial delays between the time matters get filed and when they see a court. We're essentially 3 times as long in Toronto as people are in New York City, for instance, or Buffalo. And I just think we can do substantially better. And then something that's very closely related to that, we do have artificial barriers that decrease access to justice, like silly and pointless rejection rates, and which just burn up a huge amount of time at the mag, usually to serve no purpose whatsoever that matters to anyone. And as a consequence of this, lawyers in Ontario, on average, tend to earn significantly less than lawyers in other jurisdictions like the US. But again, this isn't, believe it or not, the Law Society does not have knowledge as to how much lawyers in Ontario earn on average, because they've never taken the time to obtain that data. And so they're, literally just regulating in a vacuum. Whereas a lot of other legal regulators, they have taken the time to get that data, so they're just much better positioned to perform their function than the Law Society.
Yeah, I saw, a couple months ago that you had moved, and I think it was Cheryl seconded kind of, the access to justice committee to kind of look at some of those issues you pointed out. So maybe you could tell us a little bit more about that committee and what role could maybe they have going forward in terms of addressing some of the issues, and what else the Law Society can be doing directly there in terms of getting some of these things taken care of.
Yeah, so JP, excellent question. So I think, number one, it's hard to do, it's hard to make any change or any improvement without having some knowledge of some basic facts. So if you look at it from a foundational standpoint, should it just be me and, a few people that read my articles that are aware of, how the Ontario Superior Court functions, when everyone else is kind of just going off of their own individual, experience, or what they've seen or what they've heard? Or should this be data that is made widely available to the profession, and, for instance, shown to new, people taking the bar exam? For instance, if you had an auto case in New York State, how long would it take you to reach jury trial, in months? And how does this compare against Ontario? What are some of the differences? And either we are doing something that, is wonderful in an unquantifiable way, or we've just picked a relatively silly and inefficient procedure to do something, and we should be learning from people that know how to do it better. So one of the roles, I think the Access to Justice Committee can play, and as you might have seen at the at the convocation in public session, it was quite a contentious issue. Some people take the view that access to justice, to a large extent, that the Law Society means simply repeating the phrase a lot of times, kind of like repeating the word civility or good governance. And my personal view is they should actually be doing something about it. And one of the things they should be doing is collecting some basic data and information as to how the system's working, and essentially helping the Superior Court and the Ministry of the Attorney General. If they had the capacity to do better, I'm sure they would. But in the absence of them having that ability, I certainly think it's somewhere we could step in and fill some of that information gap. And if you saw, FOLA has just brought a motion for the annual general meeting that likewise is pushing for the Access to Justice Committee to do, or certainly the Law Society to do a lot more about the access to justice issue in rural communities.
Now, you brought up good governance there, and certainly one of the topics there, or one of the only pledges that they have if elected, is to look at election reform. And again, essentially, maybe I'm loosely paraphrasing it, but the last election they had an issue with the slates and then vote splitting, and then now they have their own group. But it's only a temporary measure, because if they're elected, then it's going to dissolve, and then take a look at electoral reform. So I guess from your perspective there, one, is there anything that threatens the self-regulation of our profession with slates? And two, regardless, is there a need for electoral reform in terms of how we choose or elect the 53 benchers that we have at the Law Society?
In terms of self-regulation, I think that, for better or worse, the Law Society is the best the public is likely to get, because if it wasn't the Law Society, it would be done by the Ministry of the Attorney General, who presumably would run regulation of lawyers and paralegals almost as well as they run the court system. So I don't, I don't see a big risk in terms of self-regulation for simply that reason. Let the Ministry of the Attorney General try to run a court system first, before they try to run a legal regulator. So that's not something that I'm particularly concerned about. And I think if there was a loss of self-regulation, that ultimately the Ministry of the Attorney General, based on how well they run the court system, would do a much worse job for the residents of Ontario than the Law Society does. And sorry, JP, that was the first half of your question. What was the other half?
Well, what about electoral reform, right? In terms of, we have 53, I guess, members of the board, if you want to call it, and issues of elections running together, all sorts of things where, again, they're saying, look, let's take a look at this. If we're elected, if does it work, with whether it's with slates, whether it's maybe getting more regional representation, maybe it's just having less people there, all sorts of things have been shared. I just wanted to know what your perspective of being on the board with 53 people, and then is there a better option?
Well, yeah, I think, you don't see militaries or companies, try to run decision through committees of 53 people. So my personal view, and, certainly to my knowledge, this isn't a slate view, or, a full stop view. My personal view is, we should look at, over the next election, so 4 years from now, having a much reduced board size, and I think there probably is some benefit to having some seats for candidates in Toronto and some seats for candidates outside Toronto. I really wouldn't be, I don't see how you could effectively bring in rules saying that, myself and my friend, Jeff, for instance, couldn't run together, and we couldn't, promote each other. I think that would certainly run into freedom of speech issues. And even though the Law Society has indicated they're very comfortable telling their lawyers and licensees what they should think and believe and say, that's never been a view that I have subscribed to.
Yeah, so let's get into, a little bit more of the full stop kind of positioning there, right? With stop bloat, stop creep, stop woke, and essentially the Law Society has lost its way. Perhaps maybe you could expand in your own take on those pillars, or whichever one. What kind of that means to you in terms of what you've seen in terms of those over the last 4 years, and I know we've touched on some of it already, but what you'd like to see over the next 4 years instead.
Yeah, so certainly my main area of interest with the Law Society in terms of its operations is probably on the financial side. I'm offended at the size of the Law Society budget, and the fact that fees are going up for lawyers, and on kind of in terms of the bloat, one of the areas of where I have concern is essentially the Law Society is, in many respects, it's making its policy in a vacuum. And I think a good example of that recently was when they up and said, hey, we've had the certified specialist program for a whole bunch of years, which by the way, a lot of other jurisdictions have as well. I know a number of certified specialists. Candidly, if they're a certified real estate specialist, my experience has been they know an awful lot more about real estate than I do. And the same thing with some of these certified specialists in some of the construction litigation, for instance. And I'm just going by a few that I deal with in my practice. But essentially, we essentially said, well, we've had this program, that a lot of our licensees have taken advantage of. Presumably, consumers have used, this designation in their decisions in terms of who to hire. We're just going to up and get rid of this, because we've decided we don't want to have it anymore. And I just think that reflects really a failure in the decision-making process. And of course, as soon as the decision was made, the Law Society was very surprised to learn people were not happy with it. The decision was then promptly reversed. I just think if they talk to more of the affected before bringing in that rule or that rule change, it would have probably never happened. So, and I think that's true of a lot of their initiatives. Another good example was recently they brought in their virtual verification rules, where essentially, my understanding, and I'm probably going to get this slightly incorrect, but the rules were that they came into force at some point between 2008 and 2015, based on what all of their friends at the other law associations in Canada were doing. And, this was back at a time when documents were still being brought to court and tribunals, with horses and carriages. We just hadn't discovered technology. The internet was unknown, and, few lawyers had discovered computers yet. Then, the Law Society says, well, guys, we gave you a little reprieve with COVID because we had to, because our lack of foresight had, essentially caused the profession to collapse and, our justice system to collapse. But, now that we're back, now that we've got it working again, we can go back to these rules, which will, be unworkable for a lot of lawyers at smaller firms and, in sole practice, or even mid-sized firms, and just make it a lot more difficult for a lot of people to do business with their clients remotely, and to help people without having to, have them drive into their offices. And so, certainly I was quite concerned about that. And along with Joseph, who's running with me on the Full Stop slate, we were able to get the Law Society to step back from doing that.
Yeah, so maybe you can expand a little bit on just sort of the process there, because I mean, those examples you brought up they don't make sense to me, or probably anyone else listening. Like, well, what's the point of going ahead? And then it almost sounds like, in Toronto, the Eglinton line, like one day it's coming, the next day it's going backwards. And so why is there such difficulty in perhaps getting through that process, making a decision, and then being satisfied with that decision?
Well, I think it's a great question. I think a lot of it really comes down to process. For the last election term, convocation has been run by the Good Governance Coalition. They don't have superiority in numbers of the 40 lawyer benchers, but they tend to vote as a block, and they're supported by typically 4 to 5 of the paralegal benchers, plus the majority of the lay benchers, meaning that they've selected the treasurer for the last 4 years. The treasurer, of course, selects who runs each committee, and so almost unanimously, the chairs and vice chairs of those committees have gone to people on the good governance side. Typically, it's those people who deal with staff, in terms of what is brought before the committee, what the committee deals with. In a lot of cases, as a member of the committee, you might get the materials, a day before, 2 days before, if they're well written. And I say this for the tribunal committee, quite often they're 20 pages. For a lot of the other committees, you might get 200, 500, 700 pages of documents, a day or two before the committee. And of course, if you're out trying to run a private practice and otherwise live life, you've got limited time to deal with it. So you're essentially given a lot of information with not enough time to process it in a lot of cases. The decision making at committee is by majority. A number of Good Governance Coalition members have been made into super benchers, with 5 to 7 committee assignments between them. I, for instance, have 2 committees. not particularly being, the favorite of Law Society management for some reason. So, ultimately, you have a smaller group at convocation and at the committees. It tends to set the agenda, and then that's what gets brought forward to the floor of convocation. And by that point, either there's going to be enough votes from the non-members of the committee to tank the recommendation, like was done with virtual verification, or that would have been done with that, or there aren't going to be, like what happened with the certified specialists, and we're going to make a poorly thought out decision, which the profession is then going to completely reject, at which point, we'll be forced to reconsider, given we probably didn't talk to licensees as much as we should have in the first place.
Yeah, and I guess perhaps maybe that explains, from talking to other people before that, hey, at the committee, Michael, I'm not necessarily you specifically, but people were all on board about the budget or this, and then I was surprised, a week later when it came to convocation, that Michael was suddenly against it, right? I mean, hypothetically, right? So is that again part of the reason is you have more time than before convocation to review some of those documents, and you're like, hey, wait a second, maybe we shouldn't go ahead with the cutting of the certified specialists or whatever it may be, and is there maybe a better process in terms of how everything gets sort of conducted to avoid that? And then again, especially because the public can tune in and watch, and you're like, well, how come it's so divided? Wouldn't they have discussed this in committee and kind of had a pretty much a good idea of where it's coming from and where the decision is going to be?
And you touched on a couple of really good points. So I think for that to work better, the committees would need to be much more representative than they have been. So I wrote a very subtle article a few months back as to whether the Law Society was run on nepotism, which I think was either in Canadian Lawyer or Lawyers Daily. I can't recall, but it looked at the makeup of the committee, and obviously, if you're only hearing from certain people who tend to all think in the same way, of course, you're going to get something that they find very pleasing. And anyone that's not in that group is going to object to quite vociferously. So I think that's part of the issue. And, kind of a related note to that is one of the problems that we've had at convocation with civility is benchers like me, quite frequently, if we ask questions to management, even though we're directors, we are not graced with a response. So an example I have of this, or one example would be when I was first elected, I wanted to know how much money the Law Society was spending, or in my view, wasting on things like ink and printers and, paper for printers. Because obviously in 2019, the Law Society was, certainly not digitized nearly to the extent they are today. So I said, this should be a relatively easy question to answer. How much do we spend on paper? How much ink did we buy? And likewise, what are printers costing us on a yearly basis? And I was told, you cannot have that information. And obviously something very similar happened to Murray Klippenstein, who had requested information on the, as to the basis for the challenges report. The Law Society effectively told him, as a director, we're not going to give it to you. And that matter is currently before the court. So, just given the dynamic at convocation, certainly the view was conveyed to management that certain directors, management doesn't answer to them. And management, listened, at least certain parts of management, really took that to heart. And just simply ignored inquiries from people, at least in theory, who were supposed to be supervising them.
Yeah, I mean, I think all this comes back to sort of the concern. A lot of, maybe everybody wants less fees, right? In terms of looking at where can those cuts be made, right? In terms of, and again, if you're not getting that information, it makes it difficult to assess. For example, if it should be coming out of the law libraries, right? That people were talking about where that funding should be coming, or how much should that funding be coming from the Law Society, or anything else that you've pointed out, right? I mean, for example, how much are the executive or the management or staff making at the Law Society, right? I mean, we have the sunshine list for high school teachers that make over $100,000, and others in the public sector. Do we have that information here, right? I mean, so what can be done to? I guess maybe you could address the law library funding there. I guess that's been a big issue, and then just generally in terms of where can we find areas, if we can find it based on the information you may have, to look at either reducing fees or just being more efficient with our fiscal responsibility.
And so, to the extent the Law Society, is the most efficient organization in the world, and I don't believe for a second they are, but if that was the case, they should have no problem following the Law Society Act, which provides a law society should operate in a transparent manner, and certainly to member inquiries. I haven't heard anyone, running on either side or independently who is pushing for a cut to the, to the law library funding, for instance. You've identified executive salaries, and certainly my view is certain folks at the top of the Law Society are being very richly compensated, and the membership should have a right to know as to how much. But that information is, confidential currently. But in terms of some specific areas, I've continued to question whether for an organization of about 570 people, we need to have a 40-person in-house computer company. I can't imagine many organizations where, close to probably just under 10% of their staff is providing IT support. I don't think a lot of Fortune 500 companies run with that kind of ratio. Likewise, a couple of areas that I've always been interested in are, do we need a 13-person HR department? And if we do need a 13-person HR department, what is wrong with working at the place? That we have this many unhappy employees. Certainly I'd like to see more direct interaction from the ventures with, the rank and file Law Society employees, so that we can, get information without having that management filter in the middle that presumably is telling us what they think we want to hear. Another area where I question the need for the Law Society to spend a lot of money is they plan to do an IT upgrade and spend somewhere between 17.5 and $20 million. Candidly, my suspicion is for their probably 70,000 licensees, give or take, there are a lot cheaper solutions that, would do good enough, and they could probably borrow one from one of the other regulators rather than making custom software from scratch at great cost.
Now, Michael, last couple of questions here. I have a number of students and other students, law students, people who are newly licensed as they kind of go through the profession. So wondering if you have any words of wisdom, any advice for them.
Well, it's certainly a great question, especially given the recent developments with artificial intelligence and things like chat GPT. Obviously, the Law Society is very much convinced that the key to being a lawyer, or at least a new lawyer in Ontario, from our bar exam is being able to look into a phone book and find John Smith, and then rinse and repeat for a few days, many hours. So I think specifically for younger lawyers, very similar to real estate, a large part of the value add is simply the client generation aspect. So that would certainly be one component for people, young lawyers and students who are, in my view, who are looking to make a steady, reliable income. And then, on a second point, I don't think there's any benefit to being as ignorant of technology as, we Ontario lawyers have historically been. We've got ourselves before COVID to be one of the worst performing, if not the worst performing jurisdiction in North America. And so I really think that we need to be looking at, what is it that got us here? And, what do we need to do to catch up with the leaders in the field? And I think that's going to be that's going to mean much greater technological proficiency. So certainly if I was, 25 years old and couldn't write basic programs in, a relatively straightforward language like Python, or couldn't read some basic statistics, for instance, I would be concerned about that. Shakespeare's a wonderful author, but Shakespeare does not provide all of the answers necessary for lawyering in the 21st century.
Perfect. So, Michael, thank you so much for taking the time and joining us here today. Last question for you, for any of the lawyers that are listening and are tuning in and watching this and making a decision, I guess now later this month, it's April 1st today. Why should they cast a vote for you?
Well, ultimately, I would ask lawyers to cast a vote for me if they want to see someone at Convocation that has no problems with trying to push law society management for change, and likewise wants to see lower fees for lawyers in the province, and wants to make sure the law society re-examines ideas for further regulation of lawyers, before giving a lot of thought to those, to those new plans. So, and likewise, I think in terms of pushing the Ontario Superior Court for change and for modernization, I'll keep doing it either way, but I think I can keep doing it much more effectively as a member of Convocation, and I would ask for the support of Ontario lawyers, so that we can keep trying to push them, for instance, to lower rejection rates, or to make the process work better for all involved, or just to get more reasonable trial times.
Perfect. So thanks again, Michael, for taking the time, and thanks for everyone for tuning in. Take care.
Thanks, JP.